Hello and welcome back to this special lecture series. My name is Taimur and I'm an attorney at law. So today we're going to be covering another important constitutional case, the Usif Patel case, which took place right after the passing of the judgment in the famous Maulvi Tamizuddin Khan case, which we covered earlier. But before we get to this case, it is rather imperative that we cover some of the underlying issues that became the center of focus before the federal court. You see, under the Government of India Act 1935, there were a great many sections which required the Governor General or the Governor of a province concerned to act in his discretion or to exercise his own individual judgment. One of those sections was Section 93, which dealt with provisions in case of constitutional machinery failing in any province. And the provision goes to the effect that if a governor of a province is satisfied that a situation has arisen in which the government of a province can no longer be carried on in accordance with the provisions of this act, then he may, by a proclamation, assume to himself all the powers vested in any body or authority in the province. Now, its a similar provision was Section 45, which dealt with the scenario of failure of constitutional machinery in a federation. However, the powers exercisable under Section 93, if I may, went one step further than our peri materia provision in our present constitution under Article 234, wherein under Section 93, the governor of a province could even assume to himself the powers exercisable by the provincial legislature, whereas in our present Article 234, those powers are to be exercised by the parliament. However, if the parliament agrees, those powers can be exercised by the president. However, coming back to this famous case. Now, under the Indian Independence Act, when it came into effect on the 15th of August 1947, which was the appointed day, Section 82C of the Indian Independence Act provided that so much of the provisions of the Government of India Act 1935, which required the Governor General or the Governor to exercise his individual judgment or an act in his discretion, shall cease to operate from the appointed day, and certain provisions, including Section 45 and Section 93, were omitted. But realizing the myriad of problems existing at the time, that there was no electoral machinery in place, delimitation and other sort of concerns and problems, even including that in certain provinces no provincial legislatures were operating, certain powers were vested in the office of the Governor General under Section 9(1) of the Indian Independence Act, that he could omit, adapt or add any of the sections of the Government of India Act 1935 into effect if the situation was deemed necessary. So when Pakistan gained independence and when this Indian Independence Act came into effect, the Governor General felt that in certain provinces, since there was no legislature, this section was rather required to administer effectively the affairs of the government. And so Section 93, the repealed Section 93, was reinserted back in the form of Section 92A. However, this was done so by the Governor General on the 19th of July 1948. Now, the problem here was that the Governor General, the powers which vested in the Governor General under the Indian Independence Act, could only be exercised for up to 7 months. So there was an expiry date which was set out under subsection 5 of Section 9, which was that he could exercise these powers up to 31st March 1948. However, Section 92A was introduced on the 19th of July 1948, which was actually 4 months after. However, this deadline was earlier extended by 1 year from 31st March 1948 to 31st March 1949 by an act of the Constituent Assembly, namely the Indian Independence Amendment Act of 1948, which was signed by the then President of Constituent Assembly on the 19th March of 1948. Another important issue before we get to this case, and I know this is becoming very technical, is that after the passing of the famous judgment in Maulvi Tamizuddin, it wasn't just Section 10 or Section 223A, but as many as 46 acts passed by the Constituent Assembly now were all deemed as invalid. And so the governance is now being called in question. So 6 days after the passing of this judgment, the Governor General Ghulam Muhammad promulgated the Emergency Powers Ordinance 9 of 1955, which among other things gave this power to the Governor General to make provision for framing the future constitution of Pakistan, as well as the power to validate all of the laws passed by the Constituent Assembly which otherwise would stand invalid, keeping in view this holding in the famous Maulvi Tamizuddin judgment. Coming to the facts of this case, the appellants were proceeded against by the District Magistrate Larkana under the Sindh Control of Hundas Act of 1952, also in short the Governors Act of 1952. These appellants were declared as Hundas under the Act, and they were directed to furnish security. However, upon refusal to do the same, they were put in detention. And against this detention order, they filed an application under section 491 CRPC, which is an application for habeas corpus. Some of the appellants filed applications under section 17 seeking revision. All of these cases came up before the Chief Court of Sindh, that ultimately dismissed all of such applications, and against the dismissal order and the decision of this Chief Court of Sindh, the appeals now came up before the federal court. And now before the federal court, a new fresh argument had been advanced by the appellants, which was that they were now also challenging the very validity of section 92A. See, the argument of the appellants was that the Governors Act of 1952 was promulgated by the governor in exercise of the powers which he had derived from section 92A. However, the problem with section 92A is that it came into operation, it was passed, it was brought into effect on the 19th of July 1948, which was 4 months after the deadline of 31st March 1948. Now, the only act which extended the deadline was the Indian Independent Act of 1948. However, since it had not received the assent of the Governor General, applying the principle of Maulvi Tamizuddin, if the Indian Independent Act of 1948 fails, then section 92A would fail, and so as such the Governors Act of 1952 would also not be legal, would also be invalid, and so the detentions would also be illegal. Now, against these arguments, the Advocate General on the other side pressed in service the recently promulgated Emergency Powers Ordinance 9 of 1955. It had two schedules. In the first schedule there were different list of laws, and on the second schedule, second column, there were different dates, and the provision were that as per the dates appearing in the second column, the laws would be deemed to have come into effect from these respective dates. Another interesting thing about this Emergency Powers Ordinance of 1955 was that there was a provision, there was an exclusion clause, that so much of certain provisions of the section could not be called in question in any court whatsoever. And perhaps many people don't realize, but the Marbury versus Madison moment, the very genesis of judicial review, if you may, could trace its origin from the Usif Patel, because the courts didn't consider this exclusion clause, and they just referred to section 205 of the Government of India Act and held that we can hear appeals. As such, we are not restricted by an exclusion clause, though they didn't elaborate that much. But this is perhaps the first time in the constitutional history that the courts just downplayed and read down this section of the provision. Now, the issues before the federal court were twofold, namely, firstly, whether the Governor General could validate the Indian Independence Act of 1948, and secondly, could he give his assent to all the laws passed by the Constituent Assembly retrospectively. And so as the court proceeded, there were two principal sections upon which the government was relying, upon which and in respect of which this Emergency Powers Ordinance had also been promulgated. There was section 42 and section 102 of the Government of India Act 1935. Section 42 provided that if the federal legislature was not in session, the Governor General, or the governor as such, could promulgate an ordinance, could pass laws, but he would be subject to the same restrictions as that of the federal legislature, whereas section 102 provided that if the Governor General has issued a proclamation of emergency, a notification to this effect has been issued under section 104, that a grave emergency exists where the security of India is threatened by war or internal disturbance, then the federal legislature can make laws for any province or any part thereof in respect of matters which were enumerated in the provincial legislative list. Proceeding onwards on the whole issue and conception of Section 42, the court ultimately held that the legislature cannot validate an invalid law if it does not have the power, if it does not possess the power to legislate on a subject to which the invalid law relates. Or in other words, that you cannot validate what you cannot legislate upon. And so the court clarified that when we said in Maulvi Tamizuddin that the Governor General has the power to withhold assent, a power which was an inherent power, it didn't imply that the Governor General could on his own exercise the powers of the Constituent Assembly. The powers to frame a constitution were entrusted only to the Constituent Assembly under the Indian Independence Act. Even the Governor General cannot exercise those powers. And so on the strength of Section 42, the court favored the appellants. The major thrust of the Section 42 argument which was held by the federal court was that the Governor General, when he was promulgating an ordinance, was subject to the like restrictions as that of the federal legislature. And since the federal legislature under Section 42 as such didn't have the power, or under any of the other section, to legislate on a matter which dealt with the Constitution, the Governor General, who was but subject to the same restrictions, could not claim any powers in excess of the powers exercisable by the federal legislature. And so this argument as such was dismissed by the federal court. The government relied on another section, 102 of the Government of India Act, to advance another argument that under Section 102 the federal legislature can pass legislation on certain residuary matters which need not be enumerated in the three lists under the Government of India Act 1935. And so here the court sort of mentioned this incident which happened during the Second World War when the Defence of India Act was passed, and under it there was Rule 75 which provided for requisition of any property by the government. There was this one incident where someone's motor car was requisitioned. He challenged this case. It went up before the Bombay High Court. His argument was that unless there is a notification which precedes under Section 102 read with Section 104 of the Government of India Act 1935, the federal legislature cannot legislate on any other matter. And so in this respective incident, the Proclamation of Emergency Act 1946 was passed when the Bombay High Court decision was challenged before the federal court. During the pendency, the Parliament of India passed this legislation which somewhat amended and changed the language of Section 102. Previously, Section 102 held that in case that Proclamation of Emergency and notification is issued, the federal legislature can pass legislation for any province or any part thereof with respect to any matter which is enumerated in the provincial legislative list. However, after the amendment in 1946, the provision read that the federal legislature could pass any laws whether for a province or any part thereof, and whether such powers are enumerated in the respective three lists in the 7th schedule. In other words, that the federal legislature can legislate even on a residuary matter that is not otherwise provided in the three respective legislative lists. However, the court held that the federal legislature, even if this notification was preceded, the federal legislature could not legislate on a matter retrospectively, because the Governor General could not by a mere notification give this power to the federal legislature. However, it opened sort of the debate to a larger point, which was that under the Indian Independence Act of 1947, the power to frame the Constitution was entrusted only to the Constituent Assembly, not the federal legislature, not the Governor General. The Governor General, if he could withhold his assent, it doesn't mean that he can exercise the powers of the respective Constituent Assembly. Another similar argument was whether he could, by giving his assent retrospectively, somehow validate the Indian Independence Act. Could he give his assent retrospectively? And so the courts delved into the very meaning of the word commencement. They tried to give it a definition under the Interpretation Act of 1889. And so under the Interpretation Act, if the word commencement is related to or is expressed in relation to an act, then it's supposed to come into effect on the day when the act as such comes into operation. If it is with respect to any day, then the act comes and commences immediately on the day preceding the expiration of the last day, on the last preceding day, on the expiration of the last day. That would be when the act would be deemed to have come into effect. However, since the Indian Independence Amendment Act 1948 did not contain any respective day upon which it was to come into operation, the whole debate about the Interpretation Act 1889 was of no effect, and so the court relied on a definition of Halsbury Laws of England, which said that the definition of the commencement is that the day when the act receives the assent or the royal assent. And so the court ultimately held that the assent was given in 1955. It wasn't given as such in 1948. And so the Governor General cannot validate either the Indian Independence Act or could give his assent retrospectively to all the laws which had been passed by the Constituent Assembly. The court, however, did give a way out. It said that with our discussion in Maulvi Tamizuddin, as we were represented, or it was informed that very soon elections would be held, that the second Constituent Assembly would be summoned, and so they sort of indicated that this is the way forward, that the Constituent Assembly alone can exercise the powers which have been vested or given to it under the Indian Independence Act. And so the appeals as such were accepted and the appellants were set free, mainly on the fact that Section 92A itself was invalid. The Governors Act of 1952 therefore consequently was also declared as invalid. In our next lecture we will be talking and picking up right from where we are leaving today, because a reference is afterwards filed by the Governor General invoking the advisory jurisdiction of the Federal Court. So I hope if there are any questions, please let us know. Thank you very much.